A lot of gun owners think the Supreme Court just ended the carry zone mess across America. Pause. That is not exactly true, and if you missed that detail, you could trust the wrong rule in the wrong place, at the worst possible time. Quick question before we continue, are you subscribed yet? Because this is the kind of update that can change how you carry, where you carry, and whether your permit protects you at all. If you want straight talk without the legal fluff, hit that subscribe button right now. Here's what just happened. The biggest carry zone case in the country right now is Wolford v. Lopez. That is the Hawaii case the Supreme Court agreed to hear. And the fight is over a rule that sounds simple, but could affect millions of permit holders if other states copy it. Hawaii says if you have a concealed carry permit, you still cannot carry on private property open to the public, unless the owner clearly says yes. Think stores, malls, hotels, parking lots, and restaurants. In plain English, the default answer is no unless the owner gives permission. Now, that may sound small at first, but let me explain why this matters. Most of your daily life happens on private property open to the public. The gas station, the grocery store, the pharmacy, the coffee shop, the hotel lobby, the shopping center. If the law says all of those places are no carry unless the owner opts in, your permit starts shrinking fast. Not because your permit vanished, but because the number of legal places you can actually carry drops hard. That is why some people call this a vampire rule. The idea is you cannot enter unless you are invited in. It is a catchy phrase, but the legal point is serious. The Supreme Court is deciding whether a state can flip the normal rule and treat regular businesses like automatic no-carry zones, unless the owner says otherwise. First thing you need to know, this fight started after the Supreme Court's 2022 Bruen decision. That ruling said the Second Amendment protects carrying a handgun in public for self-defense. After that, several states rewrote their laws fast. They expanded what they called sensitive places. That just means places where the state says you cannot carry even if you have a permit. Some states listed schools and government buildings, which are familiar examples, but others went much further and added beaches, parks, bars, museums, transit, health facilities, casinos, and large chunks of ordinary life. Second, Hawaii went further by targeting private property open to the public. That is the part the Supreme Court took up. Not every part of Hawaii's law, just that one issue. So if you hear someone say, the court is about to wipe out all carry restrictions everywhere, slow down. That is not what this case is about. This case is about whether a state can make private businesses no carry by default. Third, this matters outside Hawaii because other states tried similar moves. Some courts blocked those laws, some upheld them. That is where the confusion comes from. You can be legal in one state, cross a border, walk into the same kind of store, and suddenly face a totally different rule. Most people think Bruen made public carry simple. The truth is, Bruen opened the door and then the states started fighting over where that door actually leads. Here's a hypothetical example to explain this. Imagine you have a valid permit. You stop at a store while traveling. There is no sign on the door. In one state, no sign may mean you are fine unless the owner tells you to leave. In another state, no sign may mean carrying. There is already illegal because the owner never gave express permission. Same permit, same behavior, totally different legal risk. That is the carry zone mess the court is now staring at. If you're finding this helpful, imagine what you'll learn in my next video about the exact words you should and should not use when someone asks whether you're carrying. Subscribe so you don't miss it, because the smallest sentence can make the biggest legal difference. Now, this is where it gets interesting. When the Supreme Court heard arguments in January, the justices did not sound calm about this issue. Several of them sounded deeply bothered by Hawaii's rule. And this is the part that shocked me. The federal government backed the challengers, not Hawaii. So you had the United States telling the Supreme Court that Hawaii's default ban on carry in private businesses open to the public goes too far. Now let me break that down for you. The challengers said the state cannot turn everyday places into no-carry zones just by changing the default rule. Their point was simple. If your permit is valid, the government should not be able to erase that right across most of normal life by saying every private business is off limits unless the owner posts permission. They argued that this does not protect property rights. It targets gun owners. Hawaii pushed back hard. The state said private owners should control whether guns come onto their property. And the law simply makes that choice clearer. In other words, Hawaii says the rule protects the owner's right to decide. That argument mattered to some justices. Justice Sotomayor pressed the challengers with a blunt question. Is there really a constitutional right to walk onto someone else's property with a gun without their consent? Justice Jackson raised a similar concern and suggested this might be more of a property rights case than a straight Second Amendment case. But here's the crazy part. Other justices sounded very skeptical of Hawaii's position. Chief Justice Roberts pushed on why speech often gets one default rule, but guns get another. Justice Alito flat out said Hawaii seemed to be treating the Second Amendment like a second-class right. Justice Gorsuch questioned Hawaii's historical support and went after one old law the state relied on. That exchange got so sharp it became one of the most talked about moments of the argument. What does that tell you? It tells you the court sees this as bigger than one island state. The justices are really asking a national question. Can a state say, yes, you have a right to carry in public, but almost all the places you actually go are private, so no carry unless the owner speaks up first? If the answer is yes, then states have a roadmap. If the answer is no, then permit holders get a much stronger claim. In stores, hotels, and other businesses, unless the owner personally says no. But wait, there's something even more important. As of right now, there's not a final nationwide merits ruling in this case yet. A decision is expected by late June. That means you should not act like the law has already changed everywhere. You should act like the fight is still live, because it is. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. Here's what most people get wrong. They hear oral argument reactions and think the case is over. It is not over. A rough day at the podium can matter, but it is not the same as a final opinion. Until the court rules, your state law is still your state law. Hey, 73% of people watching updates like this are not subscribed. Don't be part of that group. Join the gun owners who want the facts before the headlines twist them. Hit subscribe and stay ahead of the next ruling instead of chasing it after the fact. So why is there so much confusion nationwide? Because the lower courts are split. And when courts split, regular people pay the price. Let's start with Maryland. On the very same day the Supreme Court heard the Hawaii case, a federal appeals court in Maryland said the state could ban carry in many places like government buildings, schools, transit and parks, museums, health facilities, stadiums, casinos, places serving alcohol, and even near public demonstrations. But that same court struck down Maryland's rule on private property open to the public. The court basically said Maryland was aiming its rule at gun owners, not protecting property rights in some new way. That matters because it means one major federal court said the default private property ban goes too far. Now jump to Hawaii and California in the Ninth Circuit. There, much more of the private property rule survived. That means one part of the country is saying states have broad room to use that default no-carry approach, while another part is saying not so fast. And when federal appeals, courts disagree like that. The Supreme Court usually steps in because the Constitution is supposed to mean the same thing in every state. Then there's New York. After Bruen, New York passed its own major carry law, the Concealed Carry Improvement Act. That law sparked huge fights over sensitive places, private property rules, and even permit standards like good moral character. The Supreme Court already sent one New York case, Antonyuk, back down for another look, after the Rahimi decision. That did not end the fight. It kept the fight alive. So when you look at New York, Maryland, Hawaii, and California together, you see the same problem over and over. States are trying different ways to limit where a licensed person can carry, and the courts keep reaching different answers. Let me make this real for you. Imagine 3 gun owners with valid permits. One lives in Maryland, one lives in Hawaii, one lives in New York. All 3 want to stop at a convenience store, pick up dinner, and head home. Same basic behavior. But the legal answer can change based on the state, the court order in effect, and the signs on the door. And whether that business falls into some listed category like alcohol service or a designated sensitive place, that is insane for regular people trying to follow the law. This is why I keep telling you not to rely on gut feeling. Do not assume private business means one thing everywhere. Do not assume no sign means you are good. Do not assume your permit works the same when you travel. And definitely do not assume the Supreme Court already fixed this. It has not. Not yet. Most people think the biggest carry fights are about permits alone. But the truth is, the real battle is often about location. You can win the right to get a permit and still lose most of the places where that permit matters. That is why this case is so important. It gets to the heart of whether a state can quietly turn ordinary life into a patchwork of default no-carry spaces. And here's the part nobody is talking about enough. Even if the challengers win, that does not mean every private business must allow carry. Owners still keep real power. A store can still post a sign. A hotel can still set rules. A restaurant can still tell you no. So this case is not about forcing guns into every business. It is about who gets to set the starting rule, the owner or the state. That difference matters more than people realize. If the owner sets the rule, you look for the business's policy. If the state sets the rule, you may be breaking the law before the owner ever says a word. That is a huge difference when you are the one carrying. Laws like this can change fast, and the next Supreme Court opinion could redraw the map overnight. Subscribe now, because when the ruling drops, I'm going to break down what changed and what did not, and exactly what gun owners need to watch before they walk into the wrong place under the wrong rule. So here is your key takeaway. The Supreme Court has not yet issued a final nationwide decision ending carry zone confusion, but it has taken the case that could do exactly that on one major issue: whether states can make private businesses no carry by default unless the owner gives express permission. If Hawaii wins, more states may try that model. If Hawaii loses, permit holders get a stronger argument that ordinary stores, hotels, and similar places cannot be turned into automatic no-carry zones by state command. And that means your next carry decision still depends on the law where you stand today, not the headline you saw this morning. So stay sharp, stay humble, and never assume the rule is the same, just because the building looks the same. If you want updates that help you protect your rights without walking into a legal trap, subscribe right now and stick with this channel. Laws change, court rulings change. Your freedom can depend on knowing the difference. And one last simple disclaimer: this video is for education only, not personal legal advice. Gun laws are different from state to state, and they can change fast. Before you carry based on any update, check your current state law and talk to a qualified attorney. If you need legal advice, stay safe and stay informed. See 2026 Script Scene Splitter, AI GitHub.